I'm the current Chief Justice of the Supreme Court, and I appreciate it. May be shocking to hear me say this, but I'm always the first person to admit that we have judges that have no business being judges. It's like
2 clicks, and there's an organization called Our Nevada Judges, a nonprofit organization. They list all the judges in the state, and you can see their discipline, if they have any, very quickly.
Good morning, everyone. Welcome to Assembly Judiciary. Welcome to those here in Carson City, as well as anyone down in Las Vegas, and those viewing online today. And with that, we will go ahead and begin. Our first bill today is Assembly Bill 141. It revises provisions related to the Judicial Department of the state government. So with that, I will go ahead and officially open up the hearing. Assembly member, do you have any co-presenters or anything with you?
No, ma'am, I don't.
Okay, well then please just introduce yourself, and then whenever you're ready, please proceed.
Great. Thank you so much. Good morning. My name is Duy Nguyen, and I have the honor of representing the Assembly District 8 in Southwest Las Vegas. Even though this is my second term, I'm still very nervous. So if I start speaking in Vietnamese, please apologize and correct me, and I'll go back to English. So let me restart on that introduction. Good morning, Chair Miller, Vice Chair Marzola, and members of the Assembly Committee on Judiciary. I'm here today to present Assembly Bill 141, which revises provisions relating to the Commission on Judicial Discipline deliberative session minutes and introduces a trial experience requirement for candidates for district judge in Nevada. As members of this committee may be aware, the Commission on Judicial Discipline play a crucial role in maintaining the integrity and accountability of our judicial system. The Commission has exclusive jurisdiction over public censure, removal, involuntary retirement, and other discipline of judges. To that end, transparency and public trust in this process is important. As a whole, AB141 addresses 2 key aspects of our judicial system. 1, the deliberative sessions of the Commission, and 2, the qualification for district judges. By making key information more accessible to the public and ensuring district judges possess practical trial experience, this bill aims to strengthen public confidence in the judiciary and enhance the quality of justice in our state. Section 1 of the bill requires that any minutes of the Commission on Judicial Discipline's proceeding be made accessible to the public while maintaining the privacy of the deliberative sessions themselves. This approach strikes a balance between protecting the privacy of the Commission's internal deliberations and ensuring transparency in its decision-making process. Concurrent to other hearings that are made accessible to the public, deliberate sessions should be held to the same standard. Judges, no matter where in the country or at whatever level, hold positions of significant authority and power. Like Spider-Man, with that power comes great responsibility. Responsibility to act with integrity, responsibility to act with fairness, and being responsible for their actions. When a judge faces charges, the public should be entitled to understand the decision regarding their conduct. In making the deliberations publicly accessible, we, the public, are provided clarity into how their actions and decisions are based on fairness and not secrecy. Moreover, the judicial process, in whatever capacity, should be fair. In knowing why judges have been charged, the public knows who they are voting for, including their history. On Section 2, amends the qualification for district judges to add requirements for candidates wishing to seek the coveted district judge office. With your permission, Chair, I have submitted a proposed conceptual amendment that clarifies some concern that I have heard from stakeholders.
I'm sorry, and is the amendment posted, or when did you submit it?
I apologize, Chair Miller, Duy Nguyen, for the record. I sent it to all the members before the meeting and made copies available for the public right now.
Okay, so it's not posted yet. Okay, thank you.
Correct. With the proposed amendment in Section 2(1)D, I removed trial from trial counsel, leaving only counsel, as well as expanding on the capacity in which one would provide counsel in at least 10 trials or arbitration in any court of forum in the state. Recognizing that leaving trial counsel might limit the pool of candidates, simply leaving counsel is intended to cover trials that happen in corporate law through arbitration and require material participation by the counsel. Often, lawyers are listed on court pleadings but have little involvement in a case. I believe this change would make the provision more practical, while still ensuring that candidates have sufficient experience for the seat that they are running for. Section 4 clarified that the additional qualification prescribed in Section 2 do not affect the current term of office of any district judge who is serving in that office as of October 1st, 2025. With that, that's the end of my presentation. So I would welcome any questions.
Okay, Assembly Member, we're going to pause for a moment because members do not have the email. It wasn't sent to members. So is there any members that have the amendment? Do you have paper copies?
Yes, I have it.
Okay, so if there's anyone that needs to, please raise your hand if you need a paper copy of the amendment. Okay, thank you. While you all are having a moment to go over that, we will begin questions from Assembly Member Ornlicker.
Thank you, Chair, and thank you for your presentation. I want to ask about the experience. I appreciate the desire to ensure there's experience. So 2 questions. One is how you settled on the number 10 and why you could have somebody who's been in 50 trials in another state, moves to Nevada, and would not qualify under this, and that seems odd. If the goal is to have trial experience, it seems like it would be not that different whether it's Nevada or Utah or other states.
Duy Nguyen for the record, through you, Chair, through the Assembly Member.
Please go direct.
Thank you. Duy Nguyen again for the record, and I think the numbers were decided just upon working with stakeholders, but we are willing to work on that number if there's a number that will be more sufficient. We definitely, again, don't want to put more restriction and have qualify candidate running for these offices, but we do want to set a bar so that we can have the ability to have qualify folks who have the trial experience needed so that on day one after they got elected, they will be successful in their role. So that number is there as, the stakeholders coming up and thought that would be a good number, but we can also work on that number if you feel that there needs to be changes to it.
Thank you. And on that they have to be in this state as opposed to a neighboring state, 50 trials in another state, you come here, you can't run for, even if you meet the other requirements about being a member of the bar.
Duy Nguyen for the record, thank you again for that. I think we want to make sure that folks understand what Nevada process is. And of course, we want folks to be familiar with Nevada laws and how things work in Nevada, because I know that all of our states have different ways of doing things. And we definitely want folks who have been here in their community, who have, know what the community is like before they make decisions that would impact our community. So I would welcome amendments or suggestion on how we can make that better, but we do want people and qualify candidates who are familiar with Nevada laws to be presiding over Nevada courts.
Thank you so much. Our next question is from Assembly Member Hardy.
Thank you, Chair. Good morning. I just want to follow up on what my colleague brought up. I too think, we want experienced people presiding over trials and courtrooms and such. So I was just curious how you came up with this bill. Like, is it from complaints of judges, or there are a lot of appeals or overturns and such like? So I just wondered how you came up with the bill. Thank you.
Duy Nguyen for the record. Thank you, Assembly Member Hardy, for the question. I think overall, in general, many constituents came to me with this issue and asked that I look not just into this role, but several other roles in our state in terms of qualifications to run. I think most of their concerns are around when there comes to judicial election, there were maybe, sometimes 60, 80 names on the ballots, and there is minimal information, even though they can go on websites, they can go on, the candidates' materials that they may get in the mail, but there isn't a way for them to see that there is qualifications that would make the process more fair for the member of the public. So these are the concerns that were brought up by my constituents, and I want to make sure that I address and listen to the constituent that we all serve.
Thank you so much. Our next question is from Assembly Member Roth.
Thank you, Chair, and thank you so much for the presentation. I guess just kind of conceptually, thinking about what kind of experience really makes a good judge. I do reach that threshold of having done 10 jury trials, but I actually think now that I practice appellate work, that experience gives me better qualifications. And so I'm wondering if there can be a bigger conversation about, I see you've included arbitration, but reaching that 10 threshold is very hard for a lot of attorneys, especially who practice in civil law, because you just go to trial a lot less. And you could have less than 10 trials under your belt, but still be qualified. So I'm wondering if you've considered kind of additional experience outside of 10 trials. I think there needs to be a bigger conversation about that.
Duy Nguyen for the record, and thank you, Assemblymember Roth, for the questions. I agree with you. I think this is still a work in progress, and as I am a legislator, I am not a lawyer. I only play one every other year. The challenges is that we want to hear from all the stakeholders in the process, and I want to make sure that we hear from everyone. So I would love to work with you, Assemblymember Roth, to add more languages that would be inclusive of all the experiences out there, because we want to make sure that folks who have relevant experience have the opportunity to declare those experiences, as well as looking into how they can meet the qualification that is relevant, so that when they do decide to run for judge, they have the ability to do so. So I would love your guidance on this and get more support on how to make this work for everyone. Thank you.
Assemblymember Roth, does that conclude your? Okay, thank you so much. We will move to Assemblymember Cole.
Good morning. Thank you. So my question is related to Section 4, where we talk about it's not going to affect or abrogate or affect the current term of office of any district judge. I think I understand the intent of that is that anybody who is a judge now doesn't have to be taken off the bench. But when they run for re-election, they may not qualify based on this. So I'm thinking you could maybe change the language to say not abrogate or affect any judge, any current judge as of this date instead.
Duy Nguyen for the record. Thank you, Assemblymember Cole, for the question. Yes, I agree with you. It is not the intent to completely clear all the benches in our state. That would be bad for our justice system. I do want to make sure that the intent is not retroactive. We are going to move from this point forward so that we can work on how to provide more training if needed, and make all of the qualification be a standard and setting the floor for Nevada. And I would love to do that. So thank you for that suggestion, and I will make sure to go back and clear the language so that we do not have the retroactive language in there. So thank you.
Thank you so much. Our next question is from Assemblymember LaRue Hatch.
Thank you, Chair. Thank you for joining us in Judiciary this morning. So my question is actually on a different section of the bill. I would like to look at the minutes of the Commission's sessions. So in that portion of the bill, it says the Commission's deliberative sessions will remain private, but the minutes must be accessible to the public. And I just read that as a little contradictory. If they're private, then when we type them up in minutes, they become public. And so can you just maybe explain how you see those two concepts working together?
Duy Nguyen for the record, and Assemblymember Hatch, thank you for catching that. I think this in drafting, we probably did not read this out loud, probably only 100 times. We'd probably need to read it out loud 101 times. So I'm going to go back and ask to make some changes in this, just to make sure that the intent was to keep private information such as addresses and phone number, or those has to do with privacy issues, but the name of the a person and the deliberation content will be public. So we just need to reword that a little bit different. So thank you for catching that. Thank you.
Thank you. Our next question is from Assemblymember Gonzalez.
Thank you, Chair. Good morning. Thank you for your presentation. My question is, there is an amendment here from the Commission on Judicial Discipline, and I was curious if you accepted this amendment. Is this a friendly amendment?
Duy Nguyen for the record. Thank you, Assemblymember Gonzalez, for the question. I have not seen that yet, so I look forward to look at it and see how we can work together on that. So thank you.
Assemblymember Deyhle, do you still have a question? Or a new one? You're good? Thank you. Okay, thank you. Okay, so I believe we have answered Assemblymember Ornlicker.
Thanks. So one of the things, we have judges who might come from civil experience presiding over criminal trials and vice versa. Your bill doesn't worry about that. Are you not concerned about that possibility? If you think it's important to have experience, should it matter whether it's criminal or civil?
Duy Nguyen for the record. Thank you, Assemblymember Ornlichter, for the question. I think I am, again, not a lawyer and not in the trial system as much, so I depend on, expert like you and Assemblymember Roth and other member of the State Bar to help me craft this in terms of getting it to where it needs to be. So thank you for bringing that up. Again, my intention is to ensure that qualification set the standard for judicial candidate for trial judges. So if those concerns that you have, whether criminal or civil attorneys who need additional clarity, we work on getting that language in to make sure that we encompasses all members of the bar, should they wish to go for judicial races, that they have the experience to truly get the vote of confidence from the public. So I look forward to getting your support on that. Thank you.
Thank you so much. Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair. Apologies, I wanted a second bite at the apple. So back to the deliberative sessions. This is not my world, and obviously I'm not in those sessions, right? And so I just wondered if you could speak a little bit to what is discussed in those sessions, what kind of information comes out, and is there anything in those sessions other than the addresses that really should remain confidential and is not something we want to get out into the public?
Duy Nguyen for the record. Thank you, Assemblymember LaRue Hatch, for the question. I think the deliberation content usually would decide what is going to happen to that particular conduct that is being investigated or being deliberated. And just to give you background, the 7 members of the commission as it stands is 2 sitting judges, 3 members of the state bar, and 2 members of the public. And in current practice, those discussion on whatever the situation might be has not been available for anything. So, for example, if a sitting judge are in that particular deliberation, if the results were either no finding of wrongdoing or findings of wrongdoing, those records are not known to the public. So, therefore, when, let's just say there's someone who did get fined or did get discipline on a certain action, that is not known to the public, and then they can be running for re-election without that particular case being available, and then the public would not know that they may be voting for someone who have had some disciplinary action that could adversely affect their ability to be impartial. So these are just part of that integrity and trust that we want to restore into our public, and we want to make sure that elected official of all roles, including our roles as legislator, to be something that everyone hold at the highest standards, and that goes for judicial system as well. So that is the intent, is just to make sure that it's not being kept behind closed door and folks don't know about what went on. So yeah, that is the intent. So thank you.
So just to follow up on that question a little bit, would it suffice if I'm thinking of an example of when I first moved here and I had a doctor here, and you can go online, kind of like a rate your doctor, and you get very brief information. It's like Yelp for doctors, right? And on there it said that she had been disciplined for basically misuse of drugs. Okay, but that's all it said. And then it went on to say that she had completed the steps that the board wanted her to, and so her license was fully intact and everything. That's literally all it said. There were no minutes. It was not a transcript. It was not whatever the actual offense, the proceedings, all the details. It was just this doctor had had a drug-related offense. This doctor had completed the requirements from the board. This doctor is still fully licensed. So that, going back to the conversation with our fellow member, would that be something that would be suffice if the goal is just to say that, you don't always know that this person has been sanctioned, as opposed to all of the details, which again could include very private, not just for the judge, but for the other members or people involved, and especially when it comes to safety and security, exposing those things. So would that be suffice?
Thank you, Chair Duy Nguyen, for the record. And I agree with you. I think that is definitely the intent of where we're going with this. And if we need to clarify the language to reflect that, again, I do not want personal private information that could jeopardize anyone's security during that process, whether it's a member of that commission or the judge in question. So for most of us who are familiar with how to look up things like that, and Chair, you are a lot more experience and knowledge in looking up things like that. Unfortunately, most members of our public, especially when it comes to the election, don't have that knowledge to do that research. So having the information, as you said, comparable to that doctor situation is so helpful to everyone. So I would, again, follow your lead to ensure that that language, the final language, to make sure that we don't provide information that could harm someone in the sense of their privacy, but at the same time, as a officer of the court or an elected member for our state. The transparency in which we are held accountable for our action is important, and that would be the primary goal, and while this at the same time ensuring safety of everyone involved.
Thank you for that. Our next question is from Assemblymember Hansen.
Thank you, Chair. And it's good to see you. Appreciate the intent. I must admit, this is the one subject on a ballot when it comes to electing judges that I get a lot of calls from friends, family, constituents, and I must admit, a lot of times it's hard to know a lot of information, and so I'll reach out maybe to people that I know that are in the legal system that might have some familiarity with the judges. But if they've never run before, you're really at a loss, right? But I do have some concerns. My colleagues have brought up on Section 1, number 3, this idea of making things public. I think, and this probably, I don't know that you can answer this, but maybe those in the audience that might have this expertise, if they come up at some point in the support, opposition, or neutral position, maybe if we can have a little bit of an understanding why there was this privacy section of the deliberations being private. I'd kind of like to know the genesis of why we've kept that, so that we can understand maybe some of the things that they do need to keep private. I think would help us understand more about what would be kind of delicate to release. So not so much if you can answer it, great, but if not, maybe somebody in the audience at some point. Thank you.
Duy Nguyen for the record. Thank you, Assemblymember Hansen, for the question. So I'm solo today. I did not bring phone a friend. So I can get that answer for you with the commission itself, should anyone in the audience does not have the information. But I think the grievances that came to me from constituents, again, highlighting their call to action, is that there have been actions in the past that were kept behind closed doors that could be, damaging, or it could be helpful at the same time, so that the voters can make informed decisions on that particular candidate. So that is the intent behind it. I would definitely get that answer for you if the answer is not provided today by any member of the audience, and I'll make sure that I'll send it to the chair so that everyone can have that answer. So thank you, Assemblymember.
Thank you. Our next question is from Assemblymember Gonzalez.
Thank you, Chair. Thank you for the additional question. I appreciate the intent of this bill, and we run bills all the time that constituents bring to us, right? And so I know that the concern is being more educated and about this topic, right? But my question is there a specific example, or is there something that happened that led to this specific piece of legislation? Obviously, I don't want you to necessarily name drop anyone, but I'm just curious, is there something that the things that already are in place are not catching in regards to this specific topic? Thank you.
Duy Nguyen for the record, and thank you, Assemblymember Gonzalez, for the follow-up questions. I think, like you said, due to the privacy of those members who are afraid of retaliation, they don't want to make their story public. But I think the gist of it is that there are concerns, and this is one way to address it. If there are more ways to address it, we would love to see how we can do that. Because again, this is not saying that everyone is bad. This is just saying how we can make the processes of disciplinary actions to be disclosed in a way where the intent of it is ensuring the public knows and trusts the action that we hold ourselves to the highest accountability. So I definitely want to echo their concerns that this is a way to do it. We look at how we can make it more accessible, and this is the first step. and I look forward to work with stakeholders who feel that there may be a different way to do this. Because as you all know, this legislative process, the hearing is just step one, and we're going to go back and see how we can come together and address all the concerns so that we can all agree and move forward. So thank you.
Thank you so much. Our next question is from Assemblymember Cole.
And I really think that what you just said probably gets to what I was going to say. The letter that was submitted by one of the members of the commission has some really good information on there, and I learned something new today, that you can actually go on their website and pull down all of their hearings. They have orders, and it has findings of fact. So I think that's really good information for people. I don't know how you tell the voters to go there because it doesn't come up in a search, right? But I think there's probably some good ways for you to amend this language. Thank you.
Thank you so much. Assembly Member Moore, did you have a question? Okay, please.
Thank you, Chair, and thank you for your presentation. I do have a question about being able to access this information. Let's say I have a neighbor that maybe is curious. Where would this information be made public, and how would the members of the public be able to access this info?
You were going for the record. Thank you, Assemblymember Moore, for the question. I think, alluding to what Assemblymember Cole just said, I think the process might be available, but you have to go through layers of websites or make the requests in a very, very convoluted way, so they may not be readily available, such simple as a Google search, right? So we want to make it accessible, and if through the feedback of the commission and other folks, if the process in place is complex, we want to simplify it. So perhaps after reviewing that letter, I would be able to come back to the committee with a gold star action to make it simple. So thank you for bringing that up.
Thank you. I'm going to ask some anecdotal questions, okay? So anecdotally, we know that often there are attorneys on both sides, the prosecution or the defense, that actually kind of, it's a form of swagger not to make it to trial, right? And so they may be very experienced, years in their field, could be possibly hundreds of cases, and may have very few trials, and feel that is a badge of their performance or excellence because it's not going to trial. So how in that case, because again, it could be someone with 20 years experience, just unlimited cases in their resume and very few trials, but again, many people in the legal community feel this is actually a sign of their exemplary skills and performance. So according to this bill, this would eliminate that person from running for a judge. So could you expand on that, please?
You were going for the record, and thank you, Chair, for the question. I think that the original language of the bill, but I think with the amendment, the conceptual amendment that was submitted, apologies for the tardiness, it opens up a little bit more. So arbitrations is part of it, and additional languages that I think would help expand, just like what Assemblymember Roth said. The trial from start to end, yes, you are correct. There are times where it's good to just settle outside, or at times to just not make it to the actual trial itself. But the trial process, including hearings, including different part of the trials, even before it gets to the jury trial, should count as well. So that's why I'm working on this with stakeholders to ensure that we look at the entire ecosystem and not just one part of it, right? So trial experience needs to be defined a little bit more in details, and that's what I need to work on still. So with your permission, Chair, I will work on the amendment some more, as this is conceptual at this point, and with the experts, member of the bar here, and adding to your stories in terms of that experience, that, again, we're not attempting to disqualifying experienced people. That is not the intent. The intent is to ensure that the right experience will be identified, so that the public know that they're not electing someone who's just walking into the role and still learning on the job. And that's the intent.
Thank you for that. And it also leads to another part of that question, and I appreciate recognizing the work that attorneys do behind the scenes, because it's just like us. We just don't show up on this dais, right? There's a lot of work, a lot of hours, things that people don't see that we actually have to do to get us to the point to get on the dais before we can actually go through a hearing on bills. And the same thing, it's not just the trial. There's a lot of work that attorneys do prior to that. So my other question about this, again, anecdotally, there's also cases where an attorney may have trial experience, but when we talk about trial experience, we have to realize that there's no specific set time to how long a trial is, right? You could go into a trial and it could be an hour and a half, it could be a year and a half, if not longer. So then how would we, to quantify it to a certain number of trials, when maybe someone has spent the last 15 years in court, but that may only equate to maybe 6 or 7 trials. And so again, how does that issue of, like a quality over quantity, again, for attorneys?
Duy Nguyen for the record, and thank you, Chair, again for the question. And I want to speak to the proposed conceptual amendment again, that we expanded that and looking at materially participated in trials or arbitration. So that does reduces those concerns that you have, and when you were talking about the length of trials, that some point it could have something that takes 3-4 years, and that could disqualify them. But we're not just specifically talking about jury trials. We can also look at bench trials, or short-term trial that could be done. Bench trials sometimes are done in one day, right? A hearing like a temporary protective order hearing, that is considered part of the trial ecosystem. So we can add that language in if it makes the committee feel more comfortable, just so that we encompasses the list of everything during the trial outside of the jury trial as well. Because I do agree with you, Madam Chair, that the jury trial is one of the most complex and lengthiest one, and we don't want just to have the candidate just have that experience by itself, but the entire trial ecosystem as part of their experience as well.
Thank you for that. And again, we all appreciate, we've all been on the side of where amendments roll in last minute. I was on that side in your committee just yesterday. And so, where we can't have them posted and meet committee deadlines. But also we all have been in the position too, where we're having the hearing and we're still in the process of working on amendments as well. So we appreciate that. With that, not seeing any additional questions, I will go ahead and open it up for testimony. So we'll start here in Carson City. Again, I ask that you state your name and please spell it so that we have it correct for the record, as well as please keep your testimonies to 2 minutes. We will begin here with testimony in support of AB141.
Good morning. I apologize for my voice, Chair Miller. This is Douglas Herndon with the Nevada Supreme Court. I'm the current Chief Justice of the Supreme Court, and I appreciate having an opportunity to be here today. It may be shocking to hear me say this, but I'm always the first person to admit that we have judges that have no business being judges. It's like any other profession. Auto mechanics, bankers, doctors, whatever it is. So I commend Assemblymember Nguyen for the spirit of the bill that seeks to improve the bench. That should always be a concern, whether you're in the legal community or not. I do not believe, however, that a hard cap metric on a specific thing that an attorney does is the best way to adjudge qualifications for somebody to be a judge. To the Assembly member's point, I can tell you that I learn something new every day. None of us come to the bench having broad knowledge on everything that we might see. So we have to be wise and listen and try and do our best to learn what we need to learn to decide issues the best we can. It's one of the benefits of being on the Supreme Court is that you have 6 other people to rely on their wisdom. But the district courts are the same way. Judges talk to judges, and they rely on each other to help them out with things. I can tell you that during the 15 years I was on the district court bench, I had multiple attorneys try multiple cases in front of me. They may have not tried 10 in front of me, but they tried way beyond 10 across the broad spectrum of the court. And I wouldn't want them to be judges. And I had attorneys that appeared in front of me on a regular basis that never tried cases, but I thought would be wonderful judges because of their experience and their knowledge. And the 2 things that I always place the biggest import on with judges, humility and work ethic. Your willingness to know what you know and don't know, and your willingness to work hard to learn what you don't know to be the best that you can be. I think the most important metric that we could have is what's already in the statute about years of practice as an attorney. That's what gives attorneys the opportunity to develop some wisdom, to develop some knowledge, to develop some experience, to learn from other attorneys, to see what's happening in the court that can make them better qualified to become judges if and when that opportunity arises for them. And I fear that the bill, to Chair Miller's point and Assemblymember Roth's point, might actually do a detriment to us. Most civil attorneys will tell you that their job is to keep their clients out of court, right? And if they get in court, to get them out of court as quickly as they can by motion practice, by settlement, by mediation, by arbitration, whatever it is, to get them out of court, not to go to trial. What I've noticed over the last several years, and I'm noticing now as the Chief Justice over the Judicial Selection Commission, is that we have fewer and fewer qualified attorneys that want to be judges. For whatever that reason may be, and I suspect a lot of it is because of the aspect of having to close a practice and potentially run an election and lose and then have to go back and start all over again. I understand that. But to take what I consider to be a large swath of very qualified civil attorneys out of the mix by saying there's a hard cap on what you've done as an attorney before you're eligible to be a judge, not only will you have fewer and fewer people seeking election, you'll have fewer and fewer seeking the appointment process as well. And we try and vet people as best we can through the appointment process for all these types of things that they've done as attorneys to try and find the best possible judges that we can. And the last thing I will tell you is that in the current state that this bill is in with this number 10 in it, we have at least one, and I believe probably 2 or 3 Supreme Court justices who would not be eligible to run for district court. They've been judges and attorneys for decades, very good judges and attorneys for decades with very good ratings and very good reputation and extraordinary experience. But they didn't do 10 trials because they were involved in civil cases. And they may not have done 10 arbitrations either, such that I don't think the mechanic that this bill is seeking to try and achieve the spirit of it is appropriate. And for those reasons, I'm in opposition. So thank you very much for your time.
Thank you so much, Chief Justice.
Thank you. John McCormick for the record, John, last name McCormick, MCCORMICK, Assistant Court Administrator at the Supreme Court. I'm just here to back the Chief Justice up and also say that we have concerns about making the private deliberations of the Judicial Discipline Committee public, as that could impact the way they are able to do business.
Thank you so much. And I didn't get to tell you the other day, good to see you back. So,
good morning, Chair Miller, committee members. For the record, my name is Paul Deyhle, D as in David, E-Y, H-L-E. I am the General Counsel and Executive Director of the Judicial Discipline Commission. And on behalf of the Commission, I am here to oppose Sections 1 and 3 of the bill. I believe you've received my letter to Chair Miller that was submitted the other day. And since I only have 2 minutes, there's a lot that I'd like to say based upon what I've heard this morning. But I would like to focus, I'm not going to reiterate my letter, but I'd like to focus on the testimony previously. And I think there's a fundamental misunderstanding of what the Commission does. And there is no secret discipline. There's no silent discipline of the Commission. when a case goes public and formal public charges are filed, there's only two things that can happen. One, there's a stipulation that's negotiated between the judge and the commission, and that stipulation is always made public. Or there's a trial on the merits, which is a public proceeding. The transcripts are public. After that hearing, the commission, the jurors, the commissioners, it's a court, as I stated in my letter, they go into private deliberations and they make a decision. And by law, the decision is memorialized in an order, and in that order are findings of fact and conclusions of law. So that is the process. There's no case where a case goes public that the commission doesn't act on. If it's dismissed, an order of dismissal will be filed. So I'm really not understanding much of what I heard earlier, with all due respect. Also, the decisions, it's like a jury. The commissioners are like juries, and I'm unaware of any court or organization that has private deliberations that are required to publish minutes of those deliberations. And
sir, we're at time. If you'd like to make your final statement.
If I may, thank you.
Yes.
Thank you very much. Also, everything is on our website. 2 clicks away, you can see our decisions. 2 clicks, and there's an organization called Our Nevada Judges, a nonprofit organization. They list all the judges in the state, and you can see their discipline, if they have any, very quickly. Thank you very much for your time.
Thank you so much.
Thank you. Duy Nguyen, for the record. Thank you, Chair and members of the committees. I've learned a lot, even in the last 10 minutes, with the intention of Assembly Bill 141. Is just simply a step forward in strengthening our judicial system and promoting public trust. You know, our court does matter, and they direct impact real people's lives. I want to say that we do have strong judges across Nevada with great experience, like our Chief Justice that you just heard from. And I know that the discussions out there is that we're trying to make it a lot harder for folks to run. And I understand that, that I can share with all of you, that I can relate to that, because, of course, you know, elected officials in our state are not well compensated. So attorneys with great experiences in their right mind, and they're having a successful practice, would never go for these positions, because, you know, you're getting a fifth of the pay and you are working a lot more hours. So I understand the complexity of this topic, and I know that even though this is a legislation as a call to action from my constituents, I did write down a lot of information from the opposition, and I will work hard to have those conversations so that we can become first in the nation to provide a guardrail needed to make sure that we have our judicial system with great knowledge, experience, and understanding of the seat that they're running for. And I urge your support with this process. We're not done yet. We're just on step 1, and I look forward to work with all the stakeholders involved, including all the opposition, and get this to the next step. So thank you for your time this morning. Thank you again, Chair, Vice Chair, and all of the members of the Judiciary Committee.
Thank you so much. And with that, I will go ahead and close the hearing on Assembly Bill 141.